I'm Spencer Mazyck, and this is another installment of our legal guide to starting a technology company. Joining us to discuss issues from a VC's perspective is early-stage venture capitalist Ian Sigalow of Greycroft Partners. He is an investor in ad technology, internet software, and mobile services. Ian has assisted several startup companies like Buddy Media, Crowdfusion, and Extreme Reach, just to name a few. Welcome, Ian. Thank you for joining us today.
Thank you for having me.
So as I mentioned there, you're a VC. You are also on the board of several startup companies, and you even started your own company. So in your experience, Ian, what is the greatest legal challenge that tech startups face?
Wow. That's a tough question. I think that there's probably, I don't know, 2 or 3 big ones, and I don't know which one specifically is the biggest, but I'll touch on a few that I can think of. One is there's always employee issues. So, you hire people. Inevitably, when you build a company, you've got your first 5 or 6 key people, and over some point in time, those people are going to change, and it's just part of growing a business. So, making sure that you put the right structures in place so that you have the ability as CEO to hire and fire people, to scale your team without having legal issues and repercussions from doing that. And I think that's very important.
By structure, what do you mean?
Certain type of employment contracts or not having employment contracts, working out with employees what their equity arrangements are going to be in advance. So here's what I'm giving you. Here's the vesting period on that equity. A common mistake that people make is they'll give someone equity without vesting, and you'll see this. And that person will leave the company, and then you'll have a big piece of your equity walking out the door, and you haven't put the right structure in place to manage that situation.
So startups ought to be very careful about that. And you said that's one, so what's two?
That's one. And the second thing is, we talk about patents, right?
Yes.
And not a week goes by where I don't have a CEO reach out to me and say, what do you recommend I do on this patent issue? Or, a lawyer thinks that this thing I invented might be patentable. And I should preface this, I invest in digital media, so this is not hard science. It's not healthcare or biotech. Yeah. So most of my companies are coming to me with business process patents. And as a CEO, they have to make an allocation of scarce resources decision. I only have so much money. Either I spend it on hiring another salesperson, or I spend it on product, or I spend it on legal. Mm-hmm. And my advice to them is, well, you should spend on legal sparingly. So if you have something...
Spend on legal sparingly. So what does that mean? And I know that a lot of attorneys are going to like to hear this.
Yeah, the attorneys listening to this. So when it comes to incorporation, setting up your company, spend what you should spend. Make sure that you go to a firm that knows what they're doing, that's been down the road and has done early stage startup work before. When it comes to IP, you have to make a business decision. Right? And the business decision is, do I take, I've raised $1 million in equity financing. Do I take $50,000 or $100,000 of that and put it into IP protection, which, by the way, if I have to prosecute that IP, I'm already in a bad place.
Okay, right.
Right? So
I'm with you there.
So the value I've seen to that IP is assuming you are successful and someone goes to acquire you, and then they want a larger amount of escrow in an acquisition just because there's an IP risk. Then if you have a big patent portfolio, you can point to it and say, well, our escrow should be less. But that is really the marginal value at the end of the day when you start looking at startup IP. For most things in digital media, if you're doing biotech or healthcare, a hard science, we have millions of dollars invested in IP before you have a product, then it's worth locking down that IP. But if you're investing in consumer web, it's better off to make sure you have a good product that consumers like, or B2B software, better to hire a salesperson and make sure that the market is there for your product.
So if I'm hearing you correctly, then it sounds like you're saying that startups should place less emphasis on IP maybe in the early stages.
In my sector, yes.
Okay. Well, and when a startup knocks at the VC door, at your door, do they already have a counsel on board who can address some of these issues for them?
Most of the time, they've got IP issues or company formation issues. So most of the time they have corporate counsel, not always. And I'd say about half the time the corporate counsel they have is the wrong kind of corporate counsel. And I'll say,
really, why?
So they'll have somebody who, let's say they're from a small town in, Pennsylvania, and they'll have a friend of a friend who did legal work for them. And the person's a lawyer, but the person has never done a venture financing before, and they don't know what NVCA standard documents look like, and they don't know what to argue for and fight for when they have negotiations.
I mean, that's a very good point, and we actually had Kane Mossa on from Goodwin Procter talking about how do you find the right attorney for your startup, and he made the very same point that you just did,
and
too.
I know Kane, and yes. Yeah.
Well, and so I wanted to ask you, too, though, you mentioned earlier that sometimes the CEO will come to you with patent questions. So are there specific legal issues, even if there's a counsel on board, that they actually, the startups present to a board for opinion, counsel, or comment?
Yes. So typically what ends up happening is they'll say, we believe there are 3 or 4 things that are patentable. Either we file a provisional patent or we go straight to the long form. And then we have a decision to make, what's the cost? What do we really want to do? Which of these items do we really think as a board we should spend time on? And most of the time, it comes down to a business decision where the CEO and the board have a discussion, and we say, look, this is the one key thing that at the end of the day, we actually need to have patent protection on, or we don't. And we'll say, for that, let's make sure that we've at least filed a provisional, if not put the patent work in place. But these other 2 things, those can wait, or we really don't think those are that important for where the business is going.
Okay, and another thing that I want to talk about today, and you raised it, the standard venture capital documents.
Yes.
What are some common provisions in those documents that relate to control that founders should absolutely be aware of?
So every founder, before they raise venture capital money, should read these documents. So that's kind of
goes without saying.
Without saying, you should know what's in them. And you just go to nvca.org, and they've been around forever. I mean, since the 70s. And so this body of work it's kind of like a form letter. It's one from column A and one from column B, and you can pick and choose, and there's founder-friendly versions and there's investor-friendly versions. And that's kind of in the preamble. The body of the document, which are the rights and the privileges and the protections of the preferred investor, which basically prevents fraudulent activity, and it gives certain control to the VCs or the private equity people doing the deal.
Controls like what?
I'll give you an example.
Yes, please do.
So specific examples, increasing the number of shares, which means if you want to raise more money, you need to issue new stock to a new investor. So that has to meet approval by the existing preferred. Changing the board. Again, this means either adding directors, replacing a CEO, bringing on a new investor because they're going to want a board seat. All of those require affirmative vote of the preferred director.
So typically, hiring and firing of the CEO
in
is
addition,
included in that.
That is explicitly stated in addition to the other 2. So specifically hiring and firing the CEO. And there's a laundry list, approving any modification to the budget in excess of Y, where Y is normally like $100,000, approving loans to other companies.
Well, and even selling the company.
Liquidating the business, yes.
And Ian, these provisions sound like they shift a lot of control from the founder to the VC. So are they negotiable? Are there ways around them so that the founder can maintain a bit more control?
So my recommendation, that the history of these documents in their entirety dates back to a time when the venture business did syndicated deals. Right? So you'd have 2 or 3 firms. In the case of FedEx, which was a VC, virtually every venture firm invested in FedEx. It was such an important deal that if FedEx failed, it might have tanked the entire venture industry, which is like a whole historical point. But you think about what the venture industry used to be. It was 3 or 4 firms coming together and investing in a company. And it would require a collective vote of those 3 or 4 firms to make these changes, and there wasn't an instance where a single firm could stymie a company, right? And that was the nature of these documents from where they began. And what's happened since, and this persisted through the 90s, and then in the last decade, venture firms have gotten bigger, and many of the big ones prefer not to syndicate anymore.
Okay.
So as an entrepreneur, where you have documents that used to appeal to a syndicated round, now you've got one sole master who has to determine whether or not you can raise more money or sell the company or fire you.
So you're saying that's not the approach that most startups should take these days?
My recommendation for startups is that they should go out assuming that they're going to find 2 investors to syndicate around. and figure out a way to structure it such that you don't have a single person who has a unanimous block.
Okay. Well, and the truth of the matter is when it comes to the hiring, the firing of a CEO, VCs aren't looking to just fire CEOs. If you're a good CEO, they're probably going to stay on board, correct?
That's correct.
Well, and
I mean, this differs. Some firms, some very well-known West Coast firms have a motto of, we don't back entrepreneurs, we replace entrepreneurs. They're crazy.
Wow, that's an insane motto.
But, I think our motto at Greycroft is we back entrepreneurs. We'd like to see them all the way through.
Well, and what makes a great CEO in your opinion?
Wow, charisma, salesmanship. The core ability of a CEO is to go out to raise money, to nurture your biggest customers, and to motivate people. Right.
Okay.
So those characteristics typically, and it's different in a B2B company or a B2C company, but in a B2B company, it's almost always someone with a good sales background. In a B2C company, you can have a product person who is, like Mark Zuckerberg, who is solely focused on product, but he himself is not a wonderful salesperson, and a company Mark with a Sheryl Sandberg and other people around the table who kind of fulfill the other parts of what would be a typical Steve Jobs CEO duty. But, in my experience, our best CEOs are out of sales and know how to build big, profitable sales organizations.
All right. Well, we're almost out of time, and I know that we're talking about legal issues today, but I can't let you go without asking you about pitching and receiving pitches. What are some common missteps that entrepreneurs make when pitching to VCs? So
one is they go directly into the detail. So a lot of these folks are out of the product side, and they're in love with the product, and they spend their entire life thinking about it, and they come in to present this business to me, and they go right for the detail. And you have to remember that VCs see, 5-6 pitches a day. Right? So I want someone to come in, and I can get the detail, but I want to understand why the space is interesting, why their team is going to succeed, and what's gone into the story to get it to where it is, not why this feature is set up this way on this slide. And
so brevity is key there.
I think brevity is key. Having a sense of the overall big picture is important, and being a good storyteller is obviously important.
Oh, wow. Well, those are some great tips there, Ian.
Yeah.
Thanks so much for joining us today. We appreciate it.
Thanks.
That's Ian Sigalow of Greycroft Partners. Stay tuned for the next installment of our series. But in the meantime, for more information on this or other topics, subscribe to BloombergLaw.com, and you can follow us on Twitter and Facebook. Thank you for joining us. Bye, everybody.